Hi, everybody. Hey, this is my third Empowering Democracy stream of today. It's another Dump the Corruption stream. The topic of it is SCOTUS, the Supreme Court of the United States, and fear of Trump. And I do not know if they are afraid of Trump, but some people seem to think that may be a possibility. There was a great article written on this subject by Dahlia Lithwick, and we will go through and we will comment on that article tonight. But first, I want to make sure I'm shared to Facebook. Yes. Yeah, Messenger is screwing me up here. It's blocking off. It's blocking me from sharing. Most annoying. Can't seem to get rid of it here. Indulge me a moment while I get this done. I guess that did it. No. Well, how do I get rid of Messenger? And that is worse than ever. Have you ever tried to close your Messenger when you want to close it? Not have to block everything else? Well, I'm not going to allow this to delay me anymore. Let's go to Dahlia Lithwick's article. This appeared in Slate. The Supreme Court can't let fear of Trump supporters force its hand. And as I said, this is by Dahlia Lithwick on February 5th, 2024, 4:56 p.m. And there's a picture of John Roberts and also the case. Donald J. Trump is the petitioner versus Norma Anderson et al. And it's a case dealing with whether Trump should be disqualified by the 14th Amendment. On Thursday, the Supreme Court will hear oral arguments, that's tomorrow, by the way, in Trump versus Anderson, also known as the 14th Amendment Disqualification Clause case. When a violent mob stormed the Capitol on January 6, 2021, Most of us looked on with frozen horror, but the minds of Civil War historians turned to Section 3 of the 14th Amendment, designed to bar former Confederates from holding public office during Reconstruction. Well, the history is not well known to the majority of us. Section 3 is what the Colorado case hangs on. And it is very well known to the many historians who signed amicus briefs laying all this out. Professor Manisha Sinha is one of 25 historians who signed on to one such brief. Her work is also cited in a second amicus brief from another group of eminent historians, including Jill Lepore. I spoke with Sinha on a recent episode of Amicus. She is the James L. and Shirley A. Dremper Chair in American History at the University of Connecticut and President-elect of the Society for Historians of the Early American Republic. Her new book, The Rise and Fall of the Second American Republic, Reconstruction 1860 to 1920, is forthcoming this March from Live Right, W.W. Norton. Our conversation has been edited for clarity. So Dahlia Lithwick said, there's a whole bunch of things the court could do without getting to the nut of the issues the historians raised. Sean Relents does a pretty masterful job in the New York Review of Books, knocking down those arguments. But the historical arguments, at least in your brief, center around two buckets of questions. One is whether Section 3 covers the president when it talks about, an officer, quote unquote. The other is whether Section 3 requires enabling legislation by Congress. So can we start with number one, and the historian's best response to this question of whether the presidency is contemplated as an office, quote unquote, in Section 3. And Manisha Sinha replied, I would say nearly all historians who studied the period agree that Section 3 covers the presidency, the vice presidency, and that it was meant to cover them, especially because the treason trial against Jefferson Davis had failed. The government just decided not to prosecute it for various reasons, and it just sort of disappeared. Some historians argued they were nervous that Davis would be able to claim secession as a constitutional right, which is what many Southern secessionists claimed, and I don't think that's correct. I think the reason they let it go is political. There were many people, especially Salmon Chase, who used to be a radical and became the Chief Justice of the Supreme Court, were very eager to run for the presidency. In those days, many Supreme Court justices actually ran for the presidency. Chase was very interested in getting the Democratic nomination, even though, of course, he had served in a Republican administration, in Lincoln's administration, and I think he served in Andrew Johnson's administration too. So there were all kinds of political calculations that his trial had failed. By 1868, it's quite clear that many of these prominent Confederates, those who had held office as cabinet officers, those who had held office as high military personnel and had defected to the Confederacy, such as Robert E. Lee, that there was no punishment coming for them. It was not disenfranchising them, which is generous. In most other countries, they would have lost their heads, right? Think of the French Revolution. For all the whining coming from the South at that time that this is Too strict? Okay. Punitive? In fact, these were generous terms. And maybe reconciliation was at the back of people's minds because they were reconstructing the Union. But they did not want to reconstruct the Union on the terms of slaveholders. They had just fought a bloody war in which more Americans died than the Vietnam Korean War, 2 world wars combined. And they were not going to have the Union reconstructed on their terms. So I think Section 3 was meant to visualize a country where slavery was gone, where everyone, regardless of race and previous condition of servitude, is a citizen, and where people who had committed treason will be barred from holding office because they had violated their oath to the U.S. Constitution. In my view, those were very generous terms, but Southerners didn't like that. They fought for amnesty, and eventually they even got amnesty. But it definitely covered the President of the United States or any office holder. The President takes an oath of office to the U.S. Constitution. Section 3 is very clear about that. So if you've taken an oath to the Constitution at any level, from the presidency to any other federal official, and committed insurrection, you will be disqualified. You don't need a trial. You don't need a punishment. I think it sounds kind of nice to say, quote, oh, someone's denied the due process of law, unquote, which also is in the 14th Amendment, right? That sounds nice, but actually on this issue in particular, okay, it's irrelevant. And Dahlia Withwick replied, the other piece of this you tackle in the brief, and that I think gets chummed up with a lot of bad history, is that we need implementing legislation. And again, I think this hangs on one decision made by Chief Justice Salmon Chase in Re Griffin in 1869. It was not a Supreme Court decision. This is known to be a kind of outlier. The only legislation that Section 3 contemplates, and that's the way out for Trump, is the amnesty. When both houses of Congress get a 2/3 majority of Republicans and get an amnesty law passed for you. That's the way a democratic process works. That's the fundamental law of the country, the Constitution. You can't invent that there has to be enabling legislation or a trial or any of that, because it's a qualification now to be a federal officer. I think it's a minimal qualification that you have not committed treason against the United States government. And Dahlia Lithwick replies or asks again, there's another historian's brief. It actually cites to your work, and it makes an argument that the brief you sign makes, but it really puts it on steroids. That brief essentially says this is not just a backward-looking enterprise, that the drafters of the 14th Amendment were not just trying to bench secessionists. They were not just trying to just resolve the problem of the Civil War and Reconstruction. They were also staving off future insurrections. And one of the things in that brief is that 5 years and 700,000 war deaths later, the framers of the 14th Amendment hoped not only to prevent a resurgence of secessionism, but also to protect future generations against insurrectionism, unquote. An early draft of Section 3 had limited the reach to those who had participated in the last insurrection, but was eliminated in favor of language that said we're looking forward to. It goes to the heart of the issue you're raising. There's no question that the drafters of Section 3 were not just thinking about past insurrections. They were thinking exactly what you were thinking on January 6th, which is, quote, here we go again, unquote. Okay, and so Manisha Sinha replies, I think that brief is really quite brilliant. It's done a wonderful job just excavating the historical reason for the 14th Amendment, including the debates in the Congressional Globe, the magazine that literally reprinted everything that people said in Congress, and it's available online. Your listeners, if they're really interested, can go back and read those debates. But that brief looks at the congressional globe, and it's clear from those debates that it's not a short term stopgap solution to the crisis they are facing, which is the major crisis of the Union until that point. A huge insurrection and a war that lasted 4 years. They are, in fact, thinking about the future of American democracy. Because when you write a constitution and you write a fundamental law of a country, it's not like a federal law that you are passing to meet the exigencies of the moment. You are writing a part of a document that you hope will be the founding document of the Republic for ages to come. And the people who wrote it are very well aware of that. So the Equal Rights Protection Clause, they actually say this in Congress, they say, who knows what rights may arise in the future that this clause might cover? So when the gay marriage issue came up, you could actually go back to somebody in the 19th century saying that we are not aware of rights that might come up, but we are going to use the broadest egalitarian language so that no group of American citizens will ever suffer any disability for any reason, that there'll be a national standard. Right? Same thing with Section 3, said Sinha. They were quite aware that even though the Confederates had been defeated, they had not accepted defeat. There were daily reports of racial massacres coming from the South, and the South was not reconciled, and the North was getting tired of what they call these, quote, annual outrages, unquote. They didn't have the political will to occupy the South or to deconfederatize it, if I can invent a word, the way you have denazification in Germany after the Second World War. They don't have the political will or the military will to do it. So the 14th Amendment is supposed to take care of that, and it is supposed to visualize the future. Dahlia Lithwick replies and says, a lot of folks are saying this is just not a good idea because they're afraid it will foment more dissatisfaction and more violence, and construct a world in which Trump supporters can say, quote, now I really am disenfranchised. But Jonathan Chait has said that to disqualify Trump would be seen forever by tens of millions of Americans as a negation of democracy. That's the political/pragmatic argument against invoking Section 3. I want to give you a chance as a historian to respond. What does history tell us about what happens when you poke the bear? What happens when you call people insurrectionists? What happens when you actually say, quote, no, you are not fit to serve, unquote? Okay, and so Manisha Sinha replies and says, this is an argument being made by a lot of people who see themselves as moderates, in the mainstream, liberals even. And they don't want to do anything that will antagonize Trump supporters. What is most dangerous, in my opinion, is in a two-party system to have one party completely taken hostage. I would ask Chait to listen to the one mainstream moderate anti-slavery politician from the 19th century, not an abolitionist, but a mainstream moderate anti-slavery politician, Abraham Lincoln. Now, before Lincoln became president, there was this idea, the controversy that actually led to the Civil War, which was the expansion of slavery into Western territories, which was really indigenous nation territories. They were visualizing that they would just dispossess them. But the controversy was not over abolition. It was over the expansion of territory into slavery into these territories. The Southerners, of course, believed slavery should expand everywhere. We should conquer Central America, Cuba. They had these grandiose pro-slavery visions. But Northern Democrats like Stephen Douglas in the Lincoln-Douglas debate says, let's let the settlers decide. Let the white settlers decide they can vote slavery up or down. That's the democratic solution. That's what he called popular sovereignty. And Lincoln is amazing. He says, that's not democracy, that's autocracy. The federal government should prohibit the expansion of slavery. It's a moral wrong. It should never be put to vote up or down. I think for somebody as dangerous an authoritarian who says, quote, when I'm elected president, I will basically dismantle our constitutional republic. I will weaponize the federal government. I will deport people who are even citizens, unquote. Take him at his word. I think this is why we have a constitutional democracy. You can put certain things to a vote, you can put certain people up on the ballot, but they have to meet certain qualifications. And I think in a country based on the rule of law, based on basic ideas of citizenship, human rights, or not allowing a really bad actor to take office, we need to be aware of this. And I would say, listen to Lincoln's Lyceum speech from 1838 when he warned that a bad actor or tyrant could take advantage. And that's when the rule of law should trump any pretended exercise in voting or democracy. And in this particular case, I really think people have gotten it wrong. They're afraid of the political violence that Trump's disqualification might incite. I am afraid of the political violence that he would unleash and then also use the instruments of the state to do that. And then you are in a position of no return. And that was Sinha's final response, okay, to Lithwick. And I think that is the most compelling response. And I am going to repeat it, okay, right now. And in this particular case, I really think people have gotten it wrong. They're afraid of the political violence that Trump's disqualification might incite. I'm afraid of the political violence that he would unleash, and then also use the instruments of state, okay, to do that. That is the critical quote. And then the final sentence, and then you are in a position of no return. Trump would unleash the political violence of the state, okay, on everyone that is in opposition to him, on everyone that does not make obeisance to him. He has said that he would do that. We must believe him. And there's no doubt that the framers of the 14th Amendment, Section 3, meant to prohibit such people from getting onto the ballot so that they would be elected the President of the United States. For such people, the easy way of the ballot must be barred to them. If they want to take over the government by violence, then they should have to organize that. They should have to attempt that. They should have to try it when someone else is in control of the instruments of state violence, and then see how successful they are. But it should not be up to the rest of us to turn over the instruments of state violence to the people who want to destroy our constitutional republic, our constitutional democracy. Of course, we have lost that in great measure already, and for other reasons. But we can peacefully gain it back. But if Trump is given the instruments of state violence, and given the statements that he has now made, we will be subject to dictatorships for a long time to come if we allow this to happen. The Supreme Court should not and cannot cave on this question. out of fear of Trump, they should vote for the 14th Amendment, Section 3. They should vote for removing Mr. Trump from all the state ballots. But if they believe they cannot do that, they at least should allow the issue to be decided on a state-by-state basis. I don't actually favor that, but that is the minimum that they must be expected to do, okay, in this case. But certainly, what they should do, the ideal thing, is just to recognize that Trump was part, okay, of an insurrection. Okay, he incited it, and therefore he's disqualified from further federal office by the 14th Amendment, Section 3. So I will see if I have any comments here. Andy says, "Hi, buddy. My 2 peas in a pod went to sleep. I'm here but late. Instruments of state. What's that? State Gestapo, like in Florida? No, things like the FBI, things like the U.S. Army, things like the state governments, okay, and the militias that they have. The federal state, specifically the United States, has the instruments of violence on the side of the state. We don't want to turn those over, okay, to Trump, as they have been turned over to your friend, okay, DeSantis in Florida. We don't want that to happen, okay, on a national basis, lest we all be forced to shut up and either mind our own business or leave the United States for those democracies that remain vital, for those republics that still exist. So that's what that's about.
He said to get rid of the Constitution.
Yes, he said he would get rid of the Constitution. He has said that, okay, as Bonnie says. So I started this stream at 10:15. I intended to go for 20 minutes. I'm a little over, but not too far over this time. Okay, I'm roughly at 30 minutes this time. So I am going to say good night. For various reasons, I wasn't able to start streaming tonight until very late, okay, until 8 o'clock. So I wasn't able to do my 3 short streams, okay, in an orderly way. However, tomorrow I will be home for most of the day, so my preparation will be much more orderly than it was today, and I hope to be able to successfully meet my goals of 3 20-minute streams. So be on the alert, okay, for notifications. Click the bell, okay, on YouTube, okay, to be notified when I stream. I don't know when I'm going to stream tomorrow. I'm going to have to work that out, okay, as I go on. But I'll be streaming. I'm sure I'll be streaming sometime tomorrow afternoon, okay, this time. I'll probably be streaming in the late afternoon and then in the early evening. Or I might be streaming at 9 o'clock. I don't know. It's going to depend on D. D filled up the 9 p.m. slot tonight. So I started streaming, okay, at 8, which is a viable time for me. But I can stream either at 8, okay, or at 9. Okay, but remember, these streams are only 20 minutes. So I can do back-to-back streams within the space of an hour if they're all pre-planned and pre-scheduled. And that is what, okay, I intend to do. And Andy says, I clicked the bell but got no dingy dings. I think that doesn't matter. Just if you click the bell, I think that you will be notified. Look for me in the early afternoon and in the late afternoon and in the early evening. I can't say that. Andy says, hi, Bonnie.
Hi.
Okay, thanks. So I'll see you tomorrow. I have a long list of things I can cover tomorrow. I haven't selected, okay, exactly what I will do tomorrow, but I will be mixing in some international relations streams here also, as well as the Dump the Corruption streams. Okay, so that's going to be what's going on. Have a very nice evening, and I will see you tomorrow. Good night.